Hi, my name is Alexandra Wood, and I'm a fellow at the Berkman Center. I'm a lawyer, and I work on the legal and policy aspects of this project. So to start, what is privacy? Alan Weston, a Columbia Law professor, said that it's the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about them is communicated to others. There is a patchwork of constitutional provisions, tort laws, federal and state statutes, regulations, agency interpretations and guidance of these laws and regulations, judicial opinions that interpret these laws, and contracts that apply to the handling of data sets. And in combination, all of these things restrict disclosures of identifiable or sensitive information about individuals and data. And what we're trying to do in this project is develop improved conceptions, definitions, and measures of privacy and utility that bridge the legal and technical approaches to privacy, and develop finely tailored tools to complement these new technical approaches to sharing research data in ways that preserve the privacy of human subjects. And on our team, we have Professor Urs Gasser, who is a professor at the law school and the executive director of the Berkman Center, David O'Brien, who's the senior researcher, and we have 4 interns this summer who are helping us with the legal work. And Salil introduced this graphic earlier. These are all the different parts of the project and how they interact within the Harvard Dataverse, and we contribute to 4 parts of this project. We contribute to the development of the DataTags generator. We work on policy proposals and best practices. We're developing a database of privacy laws and regulations, and we're developing custom and machine actionable terms of use. As mentioned, we're developing this database. We're writing legal memos. We are doing policy research. We're developing data tags. We're developing custom data sharing licenses, and we are working on bridging the gap between legal and technical definitions of privacy. So we are producing a database of privacy laws and scholarship. We're cataloging federal and state privacy laws and regulations concerning information privacy. We're looking at the types of information and the entities covered, the definitions of privacy that are used, the harms that are being sought to prevent, the enforcement mechanisms used. We're also looking at scholarship around privacy, and we've written about 50 summaries of these articles, and this all exists in a Google Drive that is used throughout the Berkman Center and by members of our project. And by the end of the project, we'll be making all of this information publicly available. We're also having students write legal memos. So these analyze privacy laws and how they apply in the research context. They look at how does the law restrict how data can be shared, and who does it apply to, what types of data does it apply to, and what are the various exceptions that allow data to be shared, such as the data can be shared if the data have been de-identified to some standard, and we look at what that standard is. So far we've looked at human subjects protection laws like the Common Rule. We looked at health records privacy laws like HIPAA privacy and security rules and the substance abuse confidentiality regulations that predated HIPAA. We're also looking at education records privacy laws like FERPA and the Protection of People Rights Amendment. And we've also looked at government records privacy laws like CIPSI, Privacy Act, Title 13, which regulates the Census Bureau. CIPSI, by the way, is the Confidential Information Protection and Statistical Efficiency Act, and it regulates statistical agencies that collect information for statistical purposes. We're also engaged in policy research. Last year, we submitted comments to 3 agencies. One set of comments looked at a proposal by the Occupational Safety and Health Administration to begin releasing workplace injury records available to the public. And the other two, our comments spoke more generally about big data and privacy. And based on these comments last year, we submitted a proposal to UC Berkeley, and they invited us to participate in their symposium last month on open data and privacy, security, and civil rights challenges of opening up access to government records. And through this work, we've been building on our prior work from the OSHA and OSTP comments to develop a new framework for analyzing privacy in open government data. In our paper, we looked at 4 different use cases of government releases of data. We looked at government releases of data in response to Freedom of Information requests. We looked at releases by statistical agencies. We looked at traditional public and vital records. And we looked at some of these new open data initiatives that are being rolled out at the federal, state, and local levels. And we made some observations about those use cases and the practices that governments currently use to share data. We found that most agencies, regardless of what laws apply, they almost always address privacy simply by withholding or redacting records that contain certain pieces of information that are considered to be directly or indirectly identifying. We also found that agencies lack formal guidance on privacy protection, in contrast to areas like security, where documentation is very thorough. Documentation on privacy is severely lacking, and a lot of agencies say they don't know how to identify information that's personally identifiable. We also found that similar privacy risks, or in some cases even identical data sets, are treated differently by different government actors. So we saw in the OSHA example that the Bureau of Labor Statistics, if it collects information from OSHA, they can only release summary data, but OSHA can release individual level records to the public because they are not bound by the Confidential Information Protection and Statistical Efficiency Act. And so we argue in this paper that based on these observations, a more formal approach to privacy is needed, and more guidance is needed so that agencies can analyze privacy risks in a more systematic fashion. So our framework recommends that agencies identify privacy vulnerabilities and threats, identify the information uses and evaluate the utility of the data, and align use, vulnerability, and threats with privacy controls at each stage of the information lifecycle. So the idea here is just to show how we are bringing together some of the different parts of the project and trying to make some of these ideas publicly accessible. We're also involved in the development of the DataTags prototype tool. And the way that we are integrating some of our legal research into the development of this tool is we are generating categories based on regulatory classifications of data. FERPA, for example, we've classified as having 6 different categories of ways that information can be shared from schools with other entities. So data can be shared because it's directory information, names and addresses, and other pieces of information that are identifying but not considered to be harmful. We have de-identified information that direct and indirect identifiers have been removed from the data, so it can be shared widely. And then there are a few exceptions under which data can be shared that's identifiable and potentially sensitive. It can be shared with consent, or it can be used for research studies under very specific circumstances. And then we've been generating questionnaires for the DataTags tool. And so what these questionnaires do is they ask a series of questions to determine which regulatory classification applies. So which of these 6 classifications, for example, would apply. And then we assign a data tag to the data set, and we also collect some properties about the data, and we also generate some license terms that apply to the data set. We'll be talking more about this process in the next presentation. The most difficult piece of this so far has been going from the regulatory classification to the data tag. And some of the challenges that we faced in doing this have led us to explore a more formal framework for the data tags process. And the idea here is to have a data tag represent the permitted and denied actions that can be taken with respect to a data set. And so we're formalizing the requirements of different laws as necessary and sufficient conditions on sharing data. And then based on which actions are permitted or denied on a given data set, you are able to determine which data tag should be assigned. So we're working closely with Micah Altman and Steve Chong to develop this formal framework. We're also analyzing data use agreements. We're collecting and cataloging data use agreements, terms of services, and policies from data repositories, academic institutions, government agencies, and businesses to better understand what common practices are for sharing data under a contract. We're clustering the license terms from these contracts into various categories within these different elements like data ownership, various conditions on sharing and use, the assignment of liability, various enforcement mechanisms, de-identification standards, and security requirements. And based on this analysis, we're drafting modules of license terms for the different classifications of data that we've identified. So for the different types of records under HIPAA, we are developing a set of license terms that seem to be a common practice for sharing those types of information. We're doing that for each of these different laws. And the goal is to deploy a license generator that works in tandem with the DataTags tool so that a custom license agreement can be generated for each data set. But there's no standard way of going about this. We have to look at the contracts that are currently being used and infer what common practice is based on what we've seen in the field. And we'd also like to use this formal framework as a way of assigning license terms to different data sets and determining what is the best way to generate a license for data that may contain information covered by different laws. So how do you develop one license that can handle different types of data and make sure that there are no conflicts within the license terms? So Steve's work is very helpful with solving those types of problems. We're also doing some work related to definitions of privacy from fields of law and mathematics. We're conducting a literature review on de-identification standards from regulations and from guidance on interpreting those regulations. We're writing an educational document that describes privacy and why privacy is important, what the various de-identification standards are, and what some of the tools that are available can offer in terms of de-identification, what some of their strengths and weaknesses are. And we're also working on a description of differential privacy that is accessible to a lay person. And ultimately, we'd like to draft an article on differential privacy in the law that compares the different definitions of privacy from the law and from differential privacy. And this will involve modeling the implicit threats that we found within laws like FERPA and HIPAA. They make a number of assumptions about the type of adversary that may be trying to learn something from the data. And so if we are able to better understand and model the assumptions that the law is making, we think that we can show that differential privacy can satisfy the legal standard. So this summer, what we hope to do is analyze a new set of laws and definitions. We're looking at state-level privacy laws for the first time. We're starting with Massachusetts and New York, which have comprehensive data protection laws. And we're also looking at the White House's Consumer Privacy Bill of Rights to see what types of definitions of privacy and de-identification the administration is considering. We would also like to refine this formal framework for data tags by testing the application of the framework to additional laws. We've developed this framework for just one law, and we'd like to see if it holds up if we try to apply it to additional laws like FERPA, HIPAA, and the Common Rule. We'll also be incorporating license terms into the formal framework so we can start to see how well this system could assign different license terms to a data set that are pulled from different laws. And we'll also be trying to take some of the legal memos and the annotated questionnaires that we've been developing for data tags and prepare them for publication. We think that a lot of the research that we've been doing in this project would be useful to the public. And so one way of doing this would be to develop a series of use cases. For example, looking at how the law would apply to new categories of data like MOOC data, massive open online course data. How does FERPA apply to those types of data? And we could write a paper that analyzes these use cases and identifies some of the common approaches to privacy protection under these laws and some of the gaps and barriers in these regulatory practices and practices that are in common use. Does anyone have any questions? I was hoping to use any additional time for the data tags presentation, which is going to run over, I think.